Hi everyone, thank you for joining us. I'm here with partner at CM Murray, Sarah Chilton, and you're joining us for our 10-minute talk series on partnerships and investigations. Kicking off today, we're going to start with the beginning of a potential investigation, and look at some of the constitutional shortfalls that we often encounter when we do want to start with an investigation. So Sarah, did you want to run into sort of maybe issues that you might have with different kind of potential investigations that you might want to undertake?
Yeah, sure. So we thought we'd talk about this because we frequently see issues crop up in investigations for firms set up as LLPs, so usually professional services practices, whereby when maybe the constitutional documentation was drafted or put into force maybe years and years and years ago, it was maybe not contemplated that you might have to do the type of investigation which we now see occurring quite regularly. One of the, I think, key features of those investigations that's relevant to what we're going to talk about is the time they can take. So I think there was time, once upon a time, where investigations were quite quick. They might have taken a few weeks to complete. We're now seeing very commonly investigations take months and months and months to complete for various factors. Often one or other party or witness will be quite unwell and unable to participate for a while. There might be complicated evidential reasons as to why things take a bit longer. The capacity of an external investigator can be harder to manage than an internal investigator. We do see a lot of firms wanting to use external investigators, particularly when we're talking about partner misconduct. So these things have all led to a situation where investigations can take, I suppose, a lot longer and be more complicated than what might have been envisaged, say, 10, 15 years ago when the relevant provisions of the LLP agreement were put into place and drafted. So I think the first place to start, and we've talked about this, is what sort of powers might you need in order to conduct your investigation and to do that in the best possible way and fairly to all parties involved. And then I suppose what sort of powers do you have or which ones are missing? And so I suppose at one end of the spectrum, you want to think about, well, what is my potential outcome going to be here? As in, if I do all this investigation, where do I potentially get to? And that question would be, well, do you have the power to remove someone if their conduct is really, really bad? And if so, what do you need to prove, or what is it that your investigation might need to tell you factually and evidentially in order for you to assess whether or not you have met or not met a threshold for removing someone from an LLP? Or are there measures short of removal, which you also need to contemplate, and you probably should be contemplating the full suite of potential sanctions if the behaviour has shown to have taken place? And what are the various different tests and thresholds for behaviour and evidence and facts that you also need to meet in order to avail yourself of those sanctions and measures that might be available in your LLP agreement? So although it might seem like going a little bit backwards because you're starting where you might end up, it's useful to know what is it that you may or may not need to demonstrate before you even decide, for example, who your investigator might be, because that might play into who you might want to pick, what type of person, what skill set they might have.
Following on from that, some of therefore the powers that we wish we saw more often would be a power to suspend, not just when someone's on their notice period, equivalent to garden leave, but more of a generic power to suspend unreasonable discretion of the management board for things like investigating medical incapacity or investigating conduct or other capacity issues. And if that is time limited, maybe making sure that it can be extended, again, with the reasonable discretion of the management board. It could be capped, so long as those extensions can be put into play as well.
It's a difficult one, isn't it? Because on the one hand, you can see why, as a partner in a firm, you would want someone like a management board to have to refer back to a wider partnership body to protect the interests of those partners. And you can understand why giving away a huge amount of power to a small number of people is not something that naturally might seem attractive to a body of partners. But actually, I think what we see in practice is if someone is the subject of an investigation, they themselves don't want that whole body of partners to know the ins and outs of that investigation until they've had a chance to put their own position forward, they've had a chance to defend themselves, they've had a chance to sort of put their side of the story. So whilst it might seem counterintuitive to gift kind of very powerful thing to a group of people, like locking you out of the business for a period of time, actually the alternative might be, well, every time you want to extend that suspension or to even have a suspension, you have to have a full equity partner vote. Well, that seems pretty unattractive, I think, as well. So it can be a really difficult one to negotiate in the drafting of an agreement, but you can see the pros and cons as to why some partners might really not want to give those sorts of powers away, and why others might be very happy that there is a much smaller number of people dealing with these quite sensitive and difficult topics.
And then that comes to that sort of firm culture point. What's the view of the management board? How are they elected? What's the cultural buy-in for the firm to be supported by and managed by this team? And if you can explain why they have these powers and the limited circumstances in which you use them and why you don't want it to go to the full partner vote, then often people do understand that, it's not just a heavy tool to be wielded when they don't like a particular partner or to be, used inappropriately. It's just in those discrete circumstances.
Yeah. And I think it's surprising, how many agreements we still see that don't have any power of suspension at all. And that produces a really difficult position for a firm, doesn't it? Where you might have someone accused of something really, really bad, whether that's really serious financial misconduct, stealing or, serious breach of SRA regulations, or whether that's very serious sexual harassment / sexual assault. And really, in any normal circumstances, you would absolutely be justified in having that person suspended for a variety of good and justifiable reasons. And if you don't have that power, you're much more stuck in a rock and a hard place. Like, do you seek to effectively protect others in the business, protect the business, try and fulfill your regulatory obligations, at the same time breaching your obligations to a partner by trying to kick them out when you don't have the power to do so, and you may not be able to do that? Or do you comply with your obligations to the partner and run all those other risks? So obviously the best solution is to make sure you've got the flexibility in the first place, but a lot of deeds still don't have that built into them.
Agreed. And that mismatch between someone who's an employee and someone who's a partner, firms, I'm sure, would be quite shocked to realize that they don't have the same power of suspension that they would for their employee that they do for their partner. And it needs to be built in. Otherwise, you can be in that tricky situation where you have the mismatch between your employees and your partnership.
Yeah. And as you say, you don't have to have it completely unfettered discretion of a small number of people. You can set it up so that you have to refer back to the wider partnership body, or you maybe have a supervisory board who you have to seek additional consent for to enable you to suspend. So it doesn't have to be all or nothing, but without it at all, it becomes really difficult to manage a difficult investigation. And one of the other points I think that we see is around incapacity, and you touched on that already, and around kind of what you can do with incapacity. I think one of the features, and I flagged at the beginning, where we see longer and longer investigations, a common feature of those lengthy investigations is that someone will be unable, from health reasons, to participate fully in investigation for quite a long period of time. There obviously comes a point where you can say, well, sorry, we need to get on with this investigation, so we'll just have to either put in place the regional adjustments that we have or go ahead without you. And that does sometimes happen. But often you're still dealing with quite a long, lengthy period. And so other powers I'd say to think about are, how do you pay someone when they're off sick for that period of time, on that basis? It may be that they are disabled under the Equality Act, but it may be that they're not. And so, the treatment of them needs to be thought about really carefully. And so thinking about your incapacity provision in your members' agreement is also a really good thing to have looked at in the context of investigations. Might not immediately spring to mind, but it is quite a relevant factor. On the one hand, it means that you can sometimes see partners being paid for a very long period of time while off sick under investigation for something quite serious. On the other hand, you have some partners who are the subject of a really long investigation and don't necessarily get entitled to, full pay or part pay throughout that. And that can have adverse consequences for them, particularly if you imagine that they're found not guilty of the conduct that they've been accused of. Then what does the firm do? How do they remedy that situation? Can they remedy that situation? So it's another factor that we see not often thought about in the context of investigation.
And people often as well haven't necessarily married their private health insurance provisions and their sort of waiting period for the kick-in of that policy with their periods of sick leave or absences. So there can often be a mismatch there, which can be leaving partners in a difficult position too.
Absolutely. And it can be complicated and difficult for firms as well, because as soon as someone becomes entitled to private medical insurance, or the potential to become entitled, there are potential other obligations that firms need to think about in terms of the risks that they will undertake if they then exit someone in those circumstances. So there's just a lot of moving parts that when you're looking at a members agreement, you sort of need to think about how all this sort of stuff fits together. And there's the other thing I'd say in this context is the kind of, when I talked about at the beginning, looking at the end, so the end product and, you know, where you might get to, is also just thinking about what options you might have. So I talked about expulsion and, you know, some sort of other sanction, but it's also quite interesting how some firms don't have the easy or maybe even the ability to actually remove partners. I think most firms now have the ability to remove partners, but I have seen firms where there's just no route to remove. But a lot of the time we might see one quite extreme route, so expulsion, no notice, quite drastic, or no route at all. And that can be quite a difficult one for a firm because meeting the threshold for expulsion might be impossible for them. The conduct might just not be in that type of realm. But they might still think, this is a risk to the business, we don't want this person in the business. And so having some other sort of route through can be a really helpful thing. So thinking about the range of different possible measures that a firm might want to take at the outcome of an investigation is a really helpful thing to do when drafting an LLP agreement. So we're talking about things like, whether you put them through a process similar to disciplinary by an employee, you know, sort of warning staged process. Whether you, in fact, have a disciplinary policy that applies to partners. A lot of firms don't have one at all. It would be helpful to have one, but obviously with some flex built in. And then whether you can remove for, you know, on notice. And then finally, whether you can remove on no notice, like expulsion, which would be equivalent to your sort of gross misconduct or dismissal if you were talking about senior executive.
That might tie into then our talk for next week then, Sarah, about actually going through that decision-making process.
Yes.
Once you have run through that investigation stage.
Yeah, there's a whole can of worms that's probably best left for another 10 minutes. It's too much to squeeze into this one. But hopefully that has been a helpful sort of summary of the things that you should be thinking about in your governance documentation that relate to partner investigations. And obviously, if you've got any questions about your documentation or queries in that respect, then we're always very happy to chat through that with you and help.
Wonderful. Well, I'll speak to you about this then soon. Thanks, Sarah.
I will do. Thanks, Liz.